Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking this morning at a book from Oxford University Press which is called Employment Tribunal Remedies. It's now in a 4th edition and it's been written by Anthony Korn and Mohinderpal Sethi. This is the book here, 450 pages, starting at the back, great index. Looking at the basic things, let's start. Mitigation of loss is very important. When you see we've got a very useful list at the beginning of what's in the chapter, and there are nice little paragraph numbering points at the side to find things very quickly. There's a lot of legislation that's all covered. And the book is actually quite nice, it's not too heavy. There's a Flickr review over there which Elizabeth and I have written, and we've given it the title Employment Tribunal Remedies, what the practitioner needs to know, because that's really what this book is about. It's very much of a hands-on book, and it's what you need to have if you're going into the tribunal and you haven't really got too much of an idea exactly what it is you want. So I mentioned mitigation of loss earlier because I think that is one of the most important areas that we have to look at the moment, because the judges certainly are very keen to see what the behaviour of the claimant has been. Let me just start by saying briefly there's a detailed statement on the web and in the journals, but what we've said in the review is that known as industrial tribunals until 1998, employment tribunals are now the main avenue for the resolution of employment disputes, although they're more formal than one has actually led to believe, and I'm certainly of the view that they are, as a concept, they were meant to be informal, but they do tend to be rather more severe and formal sometimes than county court hearings. But that's the way it's gone. If you're a practitioner or even a student involved with or specialising in any or all aspects of employment tribunals, you do well to regard this book, which is very detailed, logical and a practical approach, as an essential addition to your library. It's certainly one that I think is useful. There's a bit of blurb on the back, as you can see, about the book itself. I think, as I say, that chapter 13 on mitigation of loss is one of the more important ones, but there are lots of different remedies depending on what the sort of case that you're involved in the tribunal. I think OUP have come up with a very useful up-to-date edition here. It includes things, of course, like the Employment Equality Age Regulations 2006 and the New Equality Act 2010. The book does deal, of course, with changes to compensatory awards following the abolition of statutory dispute resolution procedures, and there's useful coverage of the new ACAS codes. To help you as a practitioner to identify key points and key issues as quickly as possible, the practical new features of this book have been added within the 23 chapters and the 4 appendices. And the underlying principle, of course, of tribunal awards are analysed in some detail, and I think that's helpful because it will give you the ability to advise the client. The title is logically structured throughout for ease of reference, and you can see the structure when you look at the book itself. And in our estimation, this is one of the most useful, if not the most useful, of the books on the market at the moment on this complex subject. And to lend further authority and aid research, there are lengthy tables of cases and the legislation which I indicated earlier, plus the appendices with forms, which of course again is quite useful. So let me conclude by saying that the book reflects the author's understanding of the law as it was in September 2010, and it's what practitioners need, in our view, to know before a tribunal appearance. So thank you very much to the authors and to OUP on an excellent book which helps us all. Thank you, bye-bye.